Third, there was an increasing level of corruption, where there was a solidification of a patron-client system within the Attorney General's office, as well as the Supreme Court, an increasing level of distrust in judicial courts by the population. And then the fourth thing to remember is that there was an intensification of a colonial era tradition. So under the British imperial system, the law was an instrument of control. It was a way of maintaining imperial order. But following independence, you had a situation where the colonial institutions remained and the British were replaced by the state, a native state, and then ultimately the military. And under the military, they basically escalated the colonial institutions, colonial mechanisms of domination and control. And out of this, you had a situation where you had it was not rule of law, but instead rule by law, where the law was an instrument of military power over Burma. And that's essentially what brought us up to about 2010, when we started to see some reforms, but we'll talk about that in a few minutes. So thank you.
Thank you so much, Jonathan, for that broad overview. My next question is for Dr. Suyin Htun. Dr. Htun, my question for you is, what exactly are the consequences of Burma's colonial and post-colonial history, both for the agency and structure of the legal profession, including law schools, lawyers, prosecutors, and judges?
Thank you so much. I'm very pleased to join with this webinar. This is a very good question. Actually, we have to look back before the colonial period, because we have Tamete, Yazete, and Cheto. Actually, the Tamete was used in court for civil suit cases, and Yazete is for criminal cases, and Cheto is combined like the judicial decisions. So, these writers and judges were written by the legal experts during the reign of the kings before the colonial period. And, the different development of the law is the rise of the legal profession, which has been known as lawyers since the dynasty. So, after the First Anglo-Burmese War, the British annexed Rakhine and Peninsula Division and signed the Treaty of Jandabo. In Peninsula Division, the first commissioner was appointed. After the Second Anglo-Burmese War, the British began establishing a legal system to strengthen the territorial integrity. So, in 1885, the British commissioner practiced law in Molamyai, firstly. Like Sitri and Rangoon, it was imported from India during the colonial times. So legal education has begun since 1878. Rangoon College was established in 1884, and Rangoon University was established in 1920, and at since time, the Department of Law was established at the Rangoon University. So, the prominent Burmese legal scholars demonstrate the importance of legal education in Myanmar before the independence. So, and then due to the efforts of the Burmese jurists, civil suits were settled with the Burmese customary law under the British rule. This is also the efforts by the Burmese scholars. And, after the Japanese invasion in 1942, the Rangoon Supreme Court suspended and the Burmese governor closed the courts. After the war in 1945, legal scholars made great efforts to draw the Constitution 1947, and many judges and politicians attended the Constitutional Conference in 1947, and Dr. Maung joined the Attorney General Office in 1953. But, in 1962, this is Dr. Jonathan already talked about that. General Nguyen threatened to seize the Chief Justice and lawyers, and because of his coup in 1959. And, the new the new justice systems and law system were introduced by Bonnewin. The new Supreme Court was established in 1962 and ended the judicial independence. So special criminal courts have diminished the role and independence of general courts. In 1972, Dr. Maung introduced the judiciary, but he removed professional judges and replaced with Burmese Socialist Program Party, BSPP, and university curricula was similarly controlled. So due to the variety of suppression by military dictator, UN clarified Myanmar as a least developed country since 1987. So, quadruple 8 uprising was happened around the country. In September 1988, SLORC, State Law and Order Restoration Council, chose the law to justify by use of force. So pro-democracy activists included lawyers and bar associations, but they were arrested. And then, I can say that legal education was very hard by the centralized education system for a long time. Universities, a lot of universities were closed at the time of quadruple 8 uprising. And when the university was reopened, Mandalay University's law departments opened in 1993, but they cannot implement the undergraduate program. And then, in 2000, the law schools, I think 17 law schools have opened across the country of universities since 2000 due to the low admission scores. Law graduate qualifications were reduced to study at these universities. But until 2012, Yangon University and many universities were open for undergraduate students, and PhD program were started since 2012 in Mandalay University. So, the legal education was hard, but I can say it was developed gradually. Yes, thank you.
Thank you, Dr. Htun, for that important timeline and that once again for that broad overview. My next question is for U Kim Maung. So U Kim Maung, I wanted to ask you about the relationship between the legal profession and the democracy movement. So I was particularly hoping that you could highlight the role of lawyer activists, which there have been many throughout the decades of the democracy movement, and the complexities of their relationship to both the legal system and the central government. Yes, please.
တော့ဒီပေခွင့်နဲ့ပတ်သက်လို့ရှိရင်တော့အပိုင်း၃ခုတွေ့ရတာပေါ့လေနော်တစ်ခုကဘာလဲဆိုတော့ဒီအခြေခံအားဖြင့်တော့ law ပေါ့ဘယ် law တွေကမြန်မာပြည်မှာကျင့်သုံးနေလဲဆိုတာကိုနားလည်ဖို့လိုတယ်ပေါ့အဓိကဆက်ဆံရေးကိုပြောချင်တာပေါ့နော်နောက်တစ်ခုကကျတော့ဒီ law တွေနဲ့ဆက်ဆက်တယ်ကျွန်တော်တို့ဒီ legal profession ပေါ့ legal profession မှာဆိုလဲဘယ်သူတွေဟာဒါဥပဒေလောကသားတွေပဲပေါ့နော်ဥပဒေလောကသားမှာဆိုလို့ရှိရင်တရားသူကြီးတွေရှိတယ်ရှင်းနေတွေရှိတယ်ရှင်းနေတယ်မှာလည်းအစိုးရရှင်းနေတွေရှိတယ်နောက်တရားရေးဝန်ထမ်းတွေရှိတယ်ပေါ့နော်နောက်တစ်ခုကတော့ဒါဒီမိုကရေစီလှုပ်ရှားမှုပေါ့ဒါကတော့မြန်မာသမိုင်းအစဉ်ဆက်ကလည်းဒီမိုကရေစီဆိုတာကဘယ်လိုပြောရမလဲကျွန်တော်တို့ကဒီအခုနလည်းပြောခဲ့ပါတယ်ဟလာကိုလိုနီစနစ်မတိုင်ခင်ခေတ်ကာလနဲ့ကိုလိုနီခေတ်ကာလနောက်ပြီးတော့ကိုလိုနီခေတ်ကနေပြီးတော့လွတ်မြောက်သွားတဲ့ဒီလွတ်လပ်ရေးခေတ်ကာလပေါ့ဒီကာလတစ်လျှောက်မှာလည်းဒီမိုကရေစီတိုက်ပွဲကတော့မြန်မာပြည်ကအဆက်ဆက်ဖြစ်နေတဲ့အခါကျတော့ဒီတိုက်ပွဲတွေနဲ့မှာပါတဲ့ဒါဒီဥပဒေလောကသားတွေဒါမှမဟုတ်တရားရေးလောကသားတွေရဲ့ဆက်ဆက်ဖို့ပေါ့နော်ဆိုတော့ဒီအချက်တွေနဲ့ပတ်သက်ပြီးကျွန်တော်အနေနဲ့ဆက်ပြောမှာပေါ့နော်တစ်ဖြတ်ပါလာပြန်လို့ရပါတယ်
So this question has to be addressed in 3 different parts. First, we should understand the people who are involved in the legal legal community. First of all, we need to understand the practice of law and who actually is practicing and what kind of laws are being practiced in Burma. The other thing is the legal profession, legal community's member. Who are the members of this community? So in other words, we would include people like judges, lawyers, country representing the national prosecutors, and also the other members of the democracy activist people. As we have talked about before, Burma has a long history of democratic struggles since before colonial time up to and during the military regime's era. So now we are talking about the lawyers who are also activists in the democracy movement.
အဲ့တော့ကျွန်တော်နားလေတလောက်ပေါ့ကျွန်တော်နားလေတလောက်ဆိုတာကမြန်မာနိုင်ငံမှာဒီကျင့်သုံးတဲ့ဥပဒေတွေကခုနဆရာမဒေါက်တာသူလည်းပြောသွားတယ်ပေါ့လေနော်သူလည်းပြောသွားတဲ့အခါကျတော့ဘာလဲဆိုတော့မြန်မာပြည်မှာတော့ဒီကိုလိုနီခေတ်မတိုင်ခင်ကတုံးတဲ့ဥပဒေတွေကိုဘယ်လိုဥပဒေမျိုးနဲ့ပဲဒီမှာကျွန်တော်နားလေကျင်တယ်လဲဆိုတော့ခြုံပြောရရင်တော့ဒါ customary law ပေါ့နော်ဒလိထုံးတမ်းဥပဒေလို့ပဲပြောချင်တယ်ခုနဓမ္မသက်တွေရစသက်တွေချက်ထုံးတွေကကျွန်တော်တို့ဒီဒလိထုံးတမ်းထဲမှာပါသွားတယ်ပေါ့လေဒါကလည်းကျွန်တော်တို့တိုင်းပြည်မှာလက်ရှိလူမှုရေးနယ်ပယ်ဘာသာရေးနယ်ပယ်နဲ့တချို့နယ်ပယ်တွေမှာတုံးနေတဲ့ဥပဒေပေါ့နောက်တစ်ခုကတော့ကိုလိုနီစနစ်ကာလမှာကိုလိုနီခေတ်ကာလမှာကျင့်သုံးတဲ့အင်္ဂလိပ်ရဲ့common law ပေါ့နော်အင်္ဂလိပ်စနစ်ကနေပြီးတော့လာတဲ့ common law ရှိတယ်နောက်တစ်ခုကကျတော့လွတ်လပ်ရေးကာလခေတ်မှာကျွန်တော်တို့ဒီ socialist ဥပဒေတွေပဲခေါ်ဒါမှမဟုတ် civil law system ရဲ့အစိပ်ပိုင်းတွေလည်းကျွန်တော်တို့တွေ့ရတာရှိတယ်နောက်တစ်ခုကကျတော့ကျွန်တော်တို့ဒီပါလီမန်ခေတ်မှာဖြစ်ပေါ်လာတဲ့ statutory law တွေပေါ့နော်လွှတ်တော်ကနေပြဋ္ဌာန်းလိုက်တဲ့ဥပဒေတွေရှိတယ်နောက်တစ်ခုကကျတော့ဒီအာဏာရှင်ခေတ်တွေမှာကျင့်သုံးတဲ့အထူးဥပဒေတွေပေါ့ဥပဒေတွေပြီးခြားပြဋ္ဌာန်းပြီးတော့ဘယ်လိုဥပဒေပြုခွင့်အာဏာရှိတဲ့အဖွဲ့အစည်းတွေကထွက်လာလဲမသိဘဲနဲ့အာဏာရှင်ခေတ်မှာအာဏာရှင်တွေတစ်ဖက်သက်ပြဋ္ဌာန်းထားတဲ့ဒါဥပဒေတွေလည်းအရင်ရှိတယ်ပေါ့နော်နောက်တစ်ခုကတော့ဒီဘက်2010 2008ဖွဲ့စည်းပုံနောက်ပိုင်းမှာဖြစ်ပေါ်လာတဲ့ဒါလွှတ်တော်တွေကနေဖြစ်ပေါ်လာတဲ့ဒီပြဋ္ဌာန်းထားတဲ့ဥပဒေတွေဆိုပြီးတော့ဒါမျိုးတွေ့ရမှာဖြစ်ပါတယ်ဒီဥပဒေတွေအများစုကိုခြုံငုံသုံးသပ်ရရင်တော့ဒါကကျွန်တော်တို့တိုင်းပြည်မှာကောင်းတဲ့ဥပဒေတွေရှိတယ်ဆိုတာကိုတော့ကျွန်တော်လက်ခံပါတယ်ဒါပေမဲ့အများစုဟာ very oppressive law တွေဖြစ်တယ်လို့ပဲကျွန်တော်အနေနဲ့ယူဆပါတယ်ဟုတ်
Historically, if we think about it, the kind of laws that were in practice before colonial era, pre-colonial era, were usually based on traditional social norms and religious practice that were prevalent at the time. And then, of course, we will also think about the common laws that came into practice during the British occupation, during the colonial era. After that, under the socialist era, we also have the kind of socialist style laws that were established at the time. And there are also laws that were established during the parliamentary era. They will be known as the statutory laws. After that, we also have to look at the kind of laws that were established and came into practice during the authoritarian eras. These are mostly the kind of laws that were passed under special order by the authorities of who knows what kind of organizations have passed them, but they are usually laws that were passed laws that were passed under the authoritarian's order. And after that, as a result of the 2008 constitution that was passed under another military dictatorship, there were additional laws that were practiced. If I have to sum up all of those things, I cannot deny that there are laws that were solid and valid and good, but most of them are highly oppressive.
အဲ့တော့ဒီဥပဒေတွေကိုကျွန်တော်အနေနဲ့ဘာလို့ဒီဖိနှိပ်တဲ့ဥပဒေတွေပြောရတယ်လဲဆိုလို့ရှိရင်ဒီကိုလိုနီခေတ်ခုနကျွန်တော်ပြောခဲ့တယ်ပေါ့နော်ကိုလိုနီခေတ်မတိုင်ခင်ကဥပဒေတွေကတော့ရှေးရိုးဆွဲစံတဲ့ဥပဒေတွေခေတ်ရဲ့တန်ဖိုးစံတွေနဲ့မမီတဲ့ဥပဒေတွေရှိတယ်တစ်ချိန်တည်းမှာပဲကိုလိုနီစနစ်ကလည်းတိုင်းပြည်တစ်ခုကိုနေချက်အုပ်ချုပ်တဲ့စနစ်ဖြစ်တဲ့အခါမှာသူ့ရဲ့အစိုးရရပ်တည်ဖို့နဲ့နော်ကိုလိုနီအစိုးရရပ်တည်ဖို့အတွက်ဒါပြည်သူတို့ civil political and civil right ပေါ့နော်ပြည်သူတွေရဲ့နိုင်ငံရေးနဲ့ဒါလူမှုရေးဆိုင်ရာလွတ်လပ်ခွင့်နဲ့နိုင်ငံသားဆိုင်ရာအခွင့်အရေးတွေကိုထိန်းချုပ်တဲ့ဖိနှိပ်ချုပ်ချယ်တဲ့ဒါဥပဒေတွေကျင့်သုံးပြဋ္ဌာန်းခဲ့တယ် ဒီဘက်မှာဆိုလို့ရှိရင်လည်းလွတ်လပ်ရေးခေတ်မှာဆိုလို့ရှိရင်လည်းဒါပါလီမန်ခေတ်ပင်ဖြစ်ပါစေပေါ့နော်အတိုက်ခံနိုင်ငံရေးသမားတွေကိုအတိုက်ခံနိုင်ငံရေးသမားတွေကိုပေါ့နောက်ပြီးတော်လှန်ရေးသမားတွေကိုပေါ့တိတိတတ်တာဖိနှိပ်တဲ့ဥပဒေကျင့်သုံးခဲ့တာလည်းရှိတယ်အာဏာရှင်ခေတ်ကတော့ပြောဖို့မလိုဘူးပေါ့နော်အဆိုးအဆုံးလို့ပြောလို့ရပါတယ်ဒီနေ့ဖေဖော်ဝါရီလဒီတရက်နောက်ပိုင်းအာဏာသိမ်းမှုနောက်ပိုင်းမှာဆိုလို့ရှိရင်လည်းဒါဥပဒေတွေကိုထင်တယ်လို့ထုတ်ပြန်ပြီးတော့ကျင့်သုံးနေတာဟာဒါအာဏာရှင်စနစ်ရဲ့ဖိနှိပ်တဲ့ဥပဒေတွေကိုထင်ဟပ်တယ်လို့ပြောလို့ရပါတယ်ဟုတ်
The laws during the colonial era, of course, they were in a way oppressive because they were based on the prevalent social norms at the time. And they were old-fashioned thinking based on that and not necessarily up to date with the way of the thinking of the time. And also during the colonial era, most of the laws were established in order to support and legitimize the colonialization. So it is usually done at the cost of the civil liberties of the people who were being governed. During the parliamentary era, during the brief parliamentary era, there were some laws that were practiced, but many of them also were designed to target the political oppositions. And of course, we are talking about the kind of laws that came into practice during the authoritarian era and the military rules. There's nothing to say about them. They are simply the worst kind. If we were to look at the kind of laws that were established after the 2021 February military coup, they were the kind of laws that were passed on a whim as they wish without any justification.
အဲ့တော့ဒီဥပဒေတွေနဲ့ပတ်သက်ပြီးတော့ကျွန်တော်ရဲ့ဒါကျွန်တော်ဘာလို့ဒီလိုမျိုးပြောရတယ်လဲဆိုတော့ဒီဥပဒေတွေကနှစ်ပေါင်းများစွာပေါ့နှစ်ပေါင်းများစွာဒီဟလာရှေးရိုးဆွဲဆန်တဲ့အတိတ်ရဲ့တန်ဖိုးတွေနဲ့ချမှတ်ထားတဲ့ဥပဒေတွေနောက်တစ်ခုကကြတော့တိုင်းပြည်နဲ့ပြည်သူရဲ့လူနေမှုဘဝတွေကိုတတောင့်တတာဖြစ်စေတဲ့ဥပဒေဆိုတာထက်ထုတ်ချယ်တဲ့ဥပဒေဖြစ်တယ်ပေါ့ဒီဥပဒေကြောင့်လူတွေကဘာလဲဆိုတော့လူနေမှုဘဝအခက်အခဲတွေပေါ့ suffocate breathing ပေါ့နော်တက်ရှင်ရက်တည်ဖို့လှုပ်ရှားဖို့အတွက်ဒီဥပဒေတွေoppressive ဥပဒေတွေဒါမှမဟုတ်ဒီနေ့ချုပ်ချယ်တဲ့ဥပဒေများလာတာဟာတိုင်းပြည်တစ်ခုမှာရှိတဲ့ပြည်သူတွေလှုပ်ရှားတာပဲဖြစ်ဖြစ်ဟလာဒီအသက်ရှင်ရက်တည်ဖို့ပဲဖြစ်ဖြစ်ခက်ခဲမှုကိုဖြစ်စေတယ်လို့ဒါကျွန်တော်ကတော့ယူဆခဲ့တယ်ပေါ့နော်အဲ့တော့မြန်မာပြည်မှာဒီလိုဥပဒေတွေများတယ်လို့ပဲသုံးသပ်ရမယ်နောက်တစ်ခုကကြတော့ဒီဥပဒေတွေကခေတ်တွေမတူတဲ့အခါမှာခေတ်စနစ်တွေမတူတဲ့အခါမှာပြဋ္ဌာန်းတဲ့ဥပဒေတွေကကွဲပြားတဲ့အခါမှာဘာဖြစ်လာလဲဆိုတော့ဥပဒေဝိယောတိဖြစ်လာတယ်ဥပဒေဝိယောတိဆိုတော့ဒီဘယ်လိုခေါ်မလဲဥပဒေအချင်းချင်းပေါ့နော်ခေတ်ကာလမတူတဲ့အခါမှာပြဋ္ဌာန်းတဲ့ဥပဒေအချင်းချင်းကြားထဲမှာပဋိပက္ခတွေဖြစ်ပြီးတော့သူတို့ဒီဥပဒေကနေပေါ်ထွက်လာတဲ့စကားရက်ဆိုင်ရာတွေအတိတ်ပဲနဲ့ပတ်သက်တဲ့ဝိဝါဒဖြစ်စရာတွေအငင်းပွားစရာတွေကဥပဒေတွေကြားထဲမှာရှင်းလင်းမနေဘူးဒါတွေနဲ့ပတ်သက်ပြီးရင်လည်းဒီတိုင်းပြည်မှာရှိတဲ့လူထုဟာအထူးသဖြင့်ပေါ့နော်ခံစားရတယ်ပေါ့နော်
Why do I say that these or most of these laws are oppressive? Well, first of all, it's because these laws don't tend to be based on the values and the social norms that are consistent with the time that we live in. And it's also because they usually tend to be, they are the kind of laws that prevent people from having a comfortable, reasonable daily life. And rather than help support the people's daily struggles and honest living, they tend to suffocate the people who are trying to make an honest living. The other problem with all of these laws that were published during the different times and eras under different administration is that we now have a lot of conflicts between the laws that came into practice during these different eras. So for example, there are a lot of consistencies between the terminologies and the definitions that were used for these particular acts and laws. So as a result of that, a lot of the definitions and terminologies and the logics of the laws are open to debate, and who suffer as a result of that? Usually the people are the one that suffer as a result of that.
အဲ့တော့ဒီလိုဥပဒေကို ကျင့်သုံးရတဲ့ကျွန်တော်တို့လိုဒီဥပဒေလောကသားပေါ့အထူးသဖြင့်တရားသူကြီးတွေရှိမယ်ကျွန်တော်တို့ရှေ့နေတွေရှိမယ်ရှေ့နေတွေမှာအစိုးရရှေ့နေရှိမယ်ဥပဒေဝန်ထမ်းတွေရှိမယ်ပေါ့အဲ့ဒီထဲမှာတရားသူကြီးတို့ဥပဒေဝန်ထမ်းတို့အစိုးရရှေ့နေတို့ဆိုတာကတော့ဒီဥပဒေတွေကိုတာဝန်ခံကျင့်သုံးရတဲ့အစိုးရကိုကိုစားပြုလှုပ်ဆောင်ရတဲ့တိုက်ပြည်ရဲ့အုပ်ချုပ်ရေးကိုကိုစားပြုလှုပ်ဆောင်ရတဲ့တရားရေးမန်တိုင်တွေကိုစားပြုလှုပ်ဆောင်ရတဲ့သူတွေဖြစ်တာကြောင့်သူတို့ကဘာနဲ့အလားတူတူလဲဆိုတော့ဒီဒီမိုကရေစီလှုပ်ရှားမှုခေတ်သမိုင်းတစ်လျှောက်ပါသူတို့ကဒီအုပ်ချုပ်ရေးရန်တရားတော့comment ဖိနှိပ်အုပ်ချုပ်ရေးရန်တရားအုပ်ချုပ်ရေးရန်တရားအတွက်ပေါ့နော်ဒီဖိနှိပ်ချုပ်ချယ်တဲ့ဥပဒေတွေကိုလက်တွေ့အကောင့်ထဲပေါ်ကျင့်သုံးရတဲ့ဒီဥပဒေစိုးမိုးရေးလုပ်ငန်းတွေကိုအဓိကလုပ်ကိုင်ရတာဖြစ်တဲ့အတွက်ကြောင့်တော်တော်များများရဲ့အမြင်မှာပြည်သူတွေရဲ့အမြင်မှာသူတို့ဟာဖိနှိပ်သူလူဒန်းစားနဲ့ရောထွေးပြီးတော့အမြင်ခံရတာရှိပါတယ်တကယ်လဲအများစုဟာအထူးသဖြင့်ပေါ့လေအထူးသဖြင့်တရားသူကြီးတို့ဒီဥပဒေဝန်ထမ်းတို့အစိုးရတက်မှတ်ပါတဲ့ဥပဒေအရာရှိတို့ဟာပြည်သူတွေအမြင်မှာဖိနှိပ်တဲ့ဥပဒေတွေကိုအကောင့်ထဲပေါ်နေတဲ့သူတွေအဖြစ်ဆက်ဆက်ပြီးတော့တွဲနေလေရှိပါတယ်အဲ့ဒီလိုအတွက်ကြောင့်လည်းခေတ်ဆက်ဆက်မှာသူတို့ဟာပြည်သူလူထုရဲ့ယုံကြည်မှုကိုအတိုင်းအတာတစ်ခုထိဆုံးရှုံးခဲ့ရတယ်လို့ကျွန်တော်မြင်ပါတယ်ဟုတ်
People who are forced to live with, contend with, and practice these laws happen to be members of the legal profession and the community. So we are talking about lawyers, judges, civil servants, and government representing prosecutors bringing cases to the court. But as a result of that, they seem to represent, in the eyes of the people who are fighting for democracy, they seem to represent part of the mechanism of oppression that is set up to control the people throughout the different ages. So most of the people lump them all together with the oppressors themselves. And as a result of that, they lost a great amount of the trust from the people as part of the mechanism of oppression.
ပေါ့တိုးတော်လည်းပဲပေါ့လေတိုးတော်လည်းပဲဒီတမိုင်းတစ်လျှောက်မှာကျွန်တော်လေ့လာသိရှိရသလောက်ပေါ့နော်တရားသူကြီးတဲ့မှာဖြစ်စေတရားကြီးဆိုင်ရာရှင်းနေတဲ့ရှင်းနေတဲ့ရှိရက်တွေကပဲဖြစ်စေပေါ့နောက်ပြီးတော့တရားရေးဝန်ထမ်းတွေကဖြစ်စေဒီမိုကရေစီလှုပ်ရှားမှုတွေမှာတကယ်ကိုရဲဝင်ပါဝင်ခဲ့တဲ့တရားသူကြီးတွေရှင်းနေတယ်အစိုးရရှင်းနေတယ်လွတ်လပ်တဲ့တတိပုဂ္ဂလရှင်းနေတွေကိုကျွန်တော်အများကြီးတွေ့ဘူးပါတယ်ဒါမှသူတို့ကတော့တခုတော့ရှိတာပေါ့လေနော်ဒီရှင်းနေတရားရေးလောကတာအတိုင်းဝိုင်းထဲမှာဆိုရင်တော့အ ਨੇ စုလို့ပြောနေတယ်အဲ့ဒီလူတွေရဲ့ပါဝင်မှုကတော့ဒီမိုကရေစီလှုပ်ရှားမှုမှာအထင်ကြီးဖြစ်တယ်တက်ရောက်မှုလည်းကြီးတယ်လို့ကျွန်တော်ကတော့ယူဆပါတယ်ဟုတ်
However, I have also met brave independent principled lawyers and judges who are part of the legal profession and members. So they participated, even though they participated in the legal system, I have to say that they are not exactly the majority, but they are rather the minority. Even though they are the minority, the kind of cases that they participate in, the kind of cases that they decided on have a huge impact on the history and the democracy movement.
ဆိုတော့အဲ့ဒီထဲမှာဆိုလို့ရှိရင်ဒါကျွန်တော်နမူနာတစ်ခုပြောပြပါတော့เนาะ1988လောက်မှာဆိုလို့ရှိရင်လည်းဒါဒီမိုကရေစီလှုပ်ရှားမှုမှာဆိုလို့ရှိရင်ဒီတရားသူကြီးတော်တော်များများကအစိုးရရဲ့ OP system ကနေပြီးတော့အခုလို commission တော့ CDM လုပ်တဲ့ခေါ်မှာပေါ့လေเนาะအဲ့ဒီတော့လည်းသူတို့ယာတူးတွေဆွလွတ်ပြီးတော့ဒီမိုကရေစီလှုပ်ရှားမှုမှာပူးပေါင်းတဲ့ထင်ကြဖြစ်ရတဲ့ရှိခဲ့တယ်နောက်ပြီးတော့မြန်မာနိုင်ငံလွတ်လပ်တဲ့အဲ့ဒီတော့မြန်မာနိုင်ငံဘာကောင်စီလို့ခေါ်တာပေါ့မြန်မာနိုင်ငံရှိနေတင်လို့ခေါ်တာပေါ့ဒါเนาะရှေ့နေတွေကနေပြီးတော့အထင်ကြီးရတဲ့1988လူထုလှုပ်ရှားမှုမှာဆိုလို့ရှိရင်ပါဝင်ခဲ့တဲ့ဒါကြောင့်လည်းအထူးသဖြင့်ရှေ့နေတွေကို target ထားပြီးတော့finite တဲ့လောက်ရက်တွေတော်တော်လေးကိုလောက်ခံခဲ့ရတာလည်းရှိတယ်ပေါ့ဒီဘက်နောက်ပိုင်းဆိုလို့ရှိရင်လည်းအားလုံးကြားဖို့မှာပါဒီ black ribbon ဆိုတဲ့ဒီဖဲဂျိုးနဲ့လှုပ်ရှားမှုတွေပါတယ်ဆိုလို့ရှိရင်လည်းဒါရှေ့နေတွေကနေပြီးတော့ဒီ2008 2010နောက်ပိုင်းမှာဆိုလို့ရှိရင်မြန်မာပြည်မှာ democracy political and civil right ဆိုတော့နိုင်ငံသားနဲ့နိုင်ငံသားအခွင့်အရေးတွေနိုင်ငံရေးအခွင့်အရေးတွေပြေဝဖို့အတွက်တနိုင်ငံလုံးလှုပ်ရှားခဲ့တဲ့ဖြစ်စဉ်တွေဟာလည်းရှိနေတယ်အများကြီးပါတာရှိပါတယ်
We think about 1988 uprising, there were also a lot of the judges and the lawyers who left their official posts and jobs in order to join the democracy movement. So at the time, of course, that was from a group that is known as the Burmese Bar Council. So in 1988, many of them participated in what is now come to known as the civil disobedience movement. We also should remember the movement that happened, the nationwide movement that happened around 2008 and 2010 that is known as the Black Ribbon Movement, that calls for political and a full protection of political and civil rights among the people.
အဲ့တော့ဒီအချက်တွေကိုဒါပြန်ကြည့်ပဲဆိုလို့ရှိရင်ပေါ့နော်မြန်မာနိုင်ငံမှာကျင့်သုံးတဲ့ဥပဒေတွေနောက်ကျွန်တော်တို့ဒီဥပဒေလောကသားတွေပေါ့နော်နောက်တစ်ခုကဒီမိုကရေစီလှုပ်ရှားမှုတွေဒီအပိုင်းမှာကျွန်တော်တို့အချင်းချင်းကြားထဲမှာအပြန်အလှန်ဆက်ဆက်မှုတွေကတော့တိတ်ပြီးတော့ဖြောင်းပြူတဲ့ပန်းခင်လန်းတော့မဟုတ်ဘူးပေါ့လေနော်ပြောချင်တာတော့ဒီပန်းပြင်း roller coaster relationship ပုံစံမျိုးပေါ့တက်လိုက်ကြလိုက်အတုံးချခိုင်ဖြစ်လိုက်တော်လှန်ရလိုက်ပေါ့နော်ဒါကတော့ကျွန်တော်တို့တကယ်လက်ရှိမြေပြင်မှာကျွန်တော်တရားသူကြီးတွေရှင်းနေတယ်နဲ့ဒီမိုကရေစီလှုပ်ရှားမှုကြားမှာတစ်ခါတလေဥပဒေနဲ့ဥပဒေတွေကဖိနှိပ်ဥပဒေဖိနှိပ်တဲ့ဥပဒေဖြစ်တဲ့အခါမှာဖိနှိပ်တဲ့ဥပဒေတွေရဲ့အတုံးချခံဖြစ်တာတွေရှိတယ်တစ်ခါတလေမှာဒီဖိနှိပ်တဲ့ဥပဒေကိုပြန်တွန်းလှန်ရတဲ့လူတွေအဖြစ်ပါဝင်ကပြရတာရှိတယ်အဲ့တော့ဒီမိုကရေစီလှုပ်ရှားမှုတမိုင်းဖြစ်စဉ်မှာဒီဥပဒေလောကသားတွေကတော့အမျိုးမျိုးပေါ့လေနော်ဘက်တိုင်းမှာလည်းရှိပါတယ်ဒါပေမဲ့သူတို့ရဲ့ဒီမိုကရေစီလှုပ်ရှားမှုမှာပါဝင်မှုပါဏနဲတော်လည်းပဲအလုံးမတန်လာဟိုအတိအမှတ်ပြုရမယ်နောက်ပြီးတော့တက်ရောက်မှုကြီးတဲ့ပါဝင်မှုတွေဖြစ်တယ်လို့သုံးသပ်လို့ရတယ်ပေါ့နော်ဟုတ်
So if I were to sum up the relationship between members of the Burmese legal profession and community and the democracy movement, there is definitely relationship and interactions between the two community. However, I wouldn't say that it's a rose-carpeted smooth path that you can walk easily on, but rather it's a roller coaster ride full of ups and downs. So sometimes because we are having to contend with oppressive laws, we are used by the legal system, that is the mechanism. Sometimes we also have the chance to stand up to the oppressive law and do something about it. So that is my summation of the kind of laws that are in practice right now. The role of the activist lawyers that played in the democracy movement, I cannot say that it's a huge role. However, it's a small role, but it's a role that should be acknowledged, and their effect is significant.
ဟုတ်အဲ့တော့ဒီဟိုခုနချက်ကိုပြန်ကောက်ရလို့ရှိရင်ကျွန်တော်တို့တိုင်းပြည်ကမတူညီတဲ့နိုင်ငံရေးစနစ်တွေမှာမတူညီတဲ့အစိုးရတွေဖြစ်ခဲ့တယ်ဆိုတာအလုံးသိပြီးဖြစ်မှာပါပေါ့နော်ကျွန်တော်တို့တိုင်းပြည်မှာရင်ဆိုင်ခဲ့ရတာကတော့ဒါကိုလိုနီခေတ်မတိုင်ခင်ကတော့တပ်ဦးဆံပိုင်ပြည်စနစ်တွေပေါ့လေနောက်ပြီးတော့ကိုလိုနီရဲ့လက်ချက်စနစ်အစိုးရတွေ့ရတယ်လွတ်လပ်ရေးပြီးခေတ်နောက်မှာတော့ကျွန်တော်တို့ပြည်သူရွေးကောက်တဲ့အစိုးရဖြစ်တယ်လို့ပဲတစ်ချိန်တည်းမှာပဲကျွန်တော်တို့ဟာဒီအာဏာရှင်စနစ်တွေအမျိုးမျိုးကိုကျွန်တော်တို့ရင်ဆိုင်ခဲ့ရတယ်တပါတီအာဏာရှင် socialist စနစ်ကိုလည်းတွေ့ရတယ်လို့စစ်အာဏာရှင်စနစ်လည်းတွေ့ခဲ့ရတယ်ပေါ့ဒီအစိုးရတွေဟာအခုနကျွန်တော်ပြောခဲ့တဲ့ဖိနှိပ်တဲ့ဥပဒေတွေကိုကျင့်သုံးတဲ့အခါမှာဒီဥပဒေကိုကျင့်သုံးရတဲ့ကျွန်တော်တို့ဥပဒေလောကသားတွေဟာဒီစစ်အစိုးရအဆက်ဆက်ပေါ့လေနော်ဒီသူအစိုးရမဟုတ်ဘူးစစ်အစိုးရအဆက်ဆက်ကကြတော့ဘယ်လိုမြင်လဲဆိုတော့ဥပဒေသမားတွေကိုသူကဒီသူတို့ရဲ့ဖိနှိပ်ချုပ်ချယ်ရေးသူတို့ရဲ့အာဏာတည်မြဲရေးအတွက်အသုံးချတဲ့ tools တွေအဖြစ်ပဲဆက်ဆံတယ်လို့ကျွန်တော်ကောက်ယူပါတယ်ဒါကဘာနဲ့ခြားနာတယ်လဲဆိုလို့ရှိရင်ပြည်သူလူထုကရွေးချယ်တင်မြှောက်တဲ့ဒီမိုကရေစီစိတ်အစိုးရတွေကနေပြီးတော့ဥပဒေလောကသားတွေနဲ့ဆက်ဆံတဲ့အခါမှာကြတော့ကျွန်တော်တို့ဟာဒီမိုကရေစီအစိုးရဖြစ်တဲ့အတွက်ပြည်သူလူထုရဲ့အသက်အိုးအိမ်စီးစိမ်ကာကွယ်ဖို့ကအဓိကprimary target ဖြစ်လာတဲ့အခါမှာဥပဒေလောကသားတွေဟာလည်းပြည်သူလူထုရဲ့အကျိုးစီးပွားကိုကာကွယ်ရသူတွေဖြစ်လာတယ်ပေါ့နော်အဲ့တော့မတူတဲ့စနစ်တစ်ခုမှာကပြအသုံးတော်ခံရတဲ့ရှင်းနေတွေဥပဒေလောကသားတွေတရားသူကြီးတွေရဲ့ကဏ္ဍဟာလည်းမတူတယ်လို့ပဲပြည်သူလူထုရဲ့တုံ့ပြန်မှုကလည်းမတူပါဘူးတနည်းအားဖြင့်အာဏာရှင်ခေတ်မှာကပြအသုံးတော်ခံရတဲ့ဒီဥပဒေလောကသားတွေကတော့ များသောအားဖြင့်လူထုရဲ့ယုံကြည်မှုတွေလူထုရဲ့ယုံကြည်မှုတွေလူထုရဲ့စိတ်ပြတ်မှုတွေခံစားရတယ်။ဘာကြောင့်လဲဆိုတော့လူထုကလည်းမတရားမှုတွေပေါ့ injustice တွေကိုခံစားကြရတယ်။ဘာကြောင့်လဲဆိုတော့ဒီဖိနှိပ်တဲ့ဥပဒေကိုကျင့်သုံးအတုံးချခံရလို့ပေါ့ဖိနှိပ်တဲ့ဥပဒေတွေစိုးမိုးဖို့အတွက်အတုံးချခံရတယ်ပေါ့အာဏာရှင်တွေရဲ့အတုံးချခံရတယ်။ဒါပေမဲ့ဒီမိုကရေစီအစိုးရတွေလက်ထက်မှာကြတော့ပြည်သူတွေကဒီရှေ့တွေနဲ့တရားသူကြီးတွေမှာအမြင်ကပြန်ကောင်းလာပြန်ရောပေါ့။ဘာလို့ပြန်ကောင်းလာလဲဆိုတော့အစိုးရတွေရဲ့ရည်ရွယ်ချက်ကမတူကြဘူးဒီမိုကရေစီအစိုးရတွေရဲ့ရည်ရွယ်ချက်နဲ့လုပ်ရတဲ့ကကြတော့ပြည်သူကိုဦးစားပေးရတယ်ပြီးတော့ public ပြည်သူ people center လုပ်ရတဲ့ခါကြတော့ပြည်သူတွေရဲ့အကျိုးစီးပွားကိုအဓိကထားတဲ့အခါမှာရှေ့တွေတို့တရားသူကြီးတို့ကလည်းဒီအစိုးရရဲ့ပုံစံနဲ့လိုက်လျောညီထွေတဲ့ဟလာကျင့်သုံးမှုမျိုးကိုကျင့်သုံးရတဲ့အခါကျတော့ပို့ပြီးတော့လူထုရဲ့ယုံကြည်မှုအားကိုးမှုနဲ့လောက်တာကြိုင်တာရှိလာတယ်လို့ဒါကောက်ချက်ချရမှာဖြစ်ပါတယ်
So before Kenneth translate, maybe we'll after he translate, maybe we'll move on. And there'll be many more opportunities to continue the discussion just in the interest of time. But I'll let you translate. Kenneth.
Sure. Because of the many different systems and many different laws that were established during the system. For example, we have the one-party socialist system. We also have successive military rules, and we also have the colonial era. However, the purpose and the functions of the law and the administration is very different, of course. Under the oppressive systems, the law is a mechanism of oppression, so people also tend to look at the people who are participating in the legal profession, members who are participating in these do not necessarily enjoy the trust of the public. The public tend to look at them as the tools that are being used by the oppressors. On the other hand, contrast to that, under a free and democratic government, the legal system, legal community members are working with the government in harmony with the government to protect the welfare of the people. So as a result, people tend to trust the legal professions a lot more during those systems.
Yeah, thank you so much, Ukemawin, for that really fascinating perspective. And we can go on to discuss some of these issues in a much more, in a deeper way later on. But I do want to keep the conversation moving a bit. And with that, I'll come to Professor John Dale. So Professor Dale, so many I would say after this coup and after the beginning of another round of protests in Burma, another cycle of demonstrations, many are not actually aware of the fact that the transnational component of the Burmese democracy movement also involved some very noteworthy cases that played out in the US courts. So if you could please describe some of the legal contestations that took place in the US courts, including their relative success and impact on the democracy movement inside of Burma.
Sure, thank you. So, in 1988, after the nationwide general strike was crushed by the Myanmar military government, they then held elections in 1990, as we know, and Aung San Suu Kyi won in a landslide, but the government did not acknowledge the results. They refused to recognize. At the same time, though, the military started to open up its markets, reversing its decades-long economic policy known as the Burmese way to socialism. And as they opened up these markets to corporate investment from around the world, they were starting to usher in a new form of development, neoliberal development around markets that included obviously teak and jade and others, but natural gas loomed large as well. At that point, the pro-democracy movement, which had seemed to be in abeyance or underground for about 4 years after that, but which had also been building relationships with other social movements around the world, human rights movements, labor movements, women's movements, environmental movements. They started to think not just about targeting the military government, but to target the relationship between the military government and these foreign corporations. Thinking about the relationship between them as a target opened up new ways of thinking about legal pressures they could bring to bear, and to try to cut off all of the foreign currency and investment that was coming in from outside of Myanmar, most of which was propping up the military government, who was spending 40% of their budget at the time on the military, and its only enemy at the time was its pro-democracy movement. That's who they were fighting. So these cases that I want to present, three in particular I want to highlight, all took place actually in the United States. So here we're talking about drawing on not international law, but laws within the United States. And they forged these with the pro-democracy movement in Myanmar through a series of what I call transnational legal campaigns. The first one was, well, I should also mention, there are actually three, there's a transnationalist discourse that grew out of these three campaigns when understood together, even though they weren't coordinated together and there was no overarching discourse, designed up front. But they were created in recognition of each other's campaigns. And they built a new discourse critical of this form of global development. The first movement challenged, the first campaign challenged the notion that market participants cannot or should not select their business partners on the basis of their moral positions. That was novel because most people were saying markets, these kinds of markets should act amorally. And not immorally, but amorally. You shouldn't choose your business partners based on their values. Then they challenged the idea that states are powerless to rein in transnational corporations. And finally, they challenged the claim that corporations, unlike most governments, are not required to respect universal human rights principles. So the first campaign that started to build this discourse was the selective purchasing campaign, or we'll call it the selective purchasing law campaign, that was initially successful at getting 30 municipal governments in the regional state of Massachusetts to legislate and enact what they called free Burma laws. The first began actually in the city of Berkeley, California, where Khin is, and I was living there at the time. But it quickly moved to cities across the United States, and as I say, the whole state of Massachusetts. And this legislation restricted a governmental entity's own ability, including the ability of its agencies and authorities, to purchase goods or services from any individuals or corporations that were engaged in business in Burma. The strategy behind proposing selective purchasing laws was to use a government's purchasing power in a transnational marketplace where it procures contracts for goods and services to force not only domestic, but also foreign corporations to make a choice: either seek profitable contracts with the local or regional government that enacted the law, or pursue contracts with the Myanmar state. In practice, these selective purchasing laws were more effective at curbing business with the Myanmar state than were the economic sanctions policy discussed at the time, but not implemented by many Western countries. The selective purchasing laws campaign successfully persuaded all but one US-based corporation and many foreign corporations as well to quit doing business with Burma. In doing so, it introduced a powerful challenge to neoliberal discourse, which claims that the market should be amoral and that it should not matter with whom a company does business. The government entities that refused to do business not only with Burma, but also any companies that did business with Burma were in effect saying that this was not true. They, as consumers, had an obligation to do business with companies that met their moral standards and who did not do business with human rights violators. The lone holdout from the US was Unical Oil Corporation. Unical was the only remaining US chartered corporation still doing business in Burma. And from the outset of the selective purchasing law campaign, it had been also the largest US-based corporate investor in Burma. In fact, it was the one that was creating the Yadana natural gas pipeline that was worth over $1.5 billion at the time, and using slave labor in Myanmar to construct that pipeline. The next campaign targeted Unical specifically, seeking to revoke its corporate charter on the basis of newly emerging evidence provided by NGOs that had documented Unical's reliance on forced labor in constructing its natural gas pipeline through Burma. And the law in California emphasizes that corporations are legal entities that owe their existence to the regional state that created them. The law also specifies conditions under which corporations may be stripped of their charters that grant their right to exist. It provides a legal procedure allowing the people of California acting, excuse me, through their attorney general to initiate the charter revocation of any of its corporations that have violated existing law. The campaign to revoke Unical's corporate charter deploys a transnational strategy through which the Free Burma movement attempted to get the California State Attorney General to bring a lawsuit on behalf of the people of California that would decharter Unical on the basis of crimes against humanity, environmental devastation, and other violations of international law that it is committed not only in California, but also Burma and other foreign states. The Free Burma movement's effort to petition the California State Attorneys General Lundgren and Lockyer, both Republican and Democrats, respectively, to bring a lawsuit against Unical that would revoke its corporate charter had mixed results. Neither attorney general was persuaded to bring such a lawsuit against Unical. In fact, they replied, do you know how much campaign financing we get from Unical? It didn't matter which party, right? This campaign's organizers never really expected that they would. The primary goal of this campaign strategy was to challenge the apologetic claim of California's regional state actors that they had no power to regulate the conduct, however morally questionable, of corporations choosing to do business with the Myanmar government in Burma. The problem these politicians frequently suggested is that the conduct of the Myanmar government, the conduct of corporations in Burma falls within the administrative jurisdiction of the Myanmar government. And the Myanmar government has greeted these corporations and their conduct with open arms, despite their domestic citizenry's outcry to the international community for economic sanctions. This campaign sought to educate the public about the legal power that regional states in the United States have to challenge the misconduct of the corporations that they charter, regardless of where in the world those corporations conduct their business. It sought to show that Unical's violations of human rights in Burma could be stopped by California's legal administrators if they had the political and moral will to do so, because the state of California had chartered Unical, and California's legal administrators have the legal grounds and power to revoke Unical's charter. So in doing so, the campaign employed a transnationalist discourse to suggest that despite the protests of governments, that they are powerless to rein in transnational corporations, local, state, and federal governments still held considerable power in the age of globalization. What the campaign pointed out was that states don't necessarily lack the power to act, it's that they often lack the will. And then the final campaign, final transnational legal campaign, focuses on a legal space that was provided by what's called the United States Alien Tort Claims Act, which which the first Congress of the United States adopted in 1789, but it had remained largely unused for the next 2 centuries. The statute asserts very simply that the district courts shall have original jurisdiction of any civil action by an alien, that is a non-US citizen, for a tort, that is a harm or a wrong only, committed in violation of the law of nations or the Treaty of the United States. More recently, the statute's been invoked, or had been invoked, to hold states and their agents accountable for violations of international law committed outside of the United States. But in 1996, a dozen peasants from Burma filed a suit against Unical Oil Corporation, alleging that it was complicit and even benefited from slave labor and other severe human rights abuses committed in Burma. In the suit called Doe versus Unical, filed under the Alien Tort Claims Act, the movement actors, this time in the role of plaintiffs to the lawsuit and their supporters, deployed a transnational discourse to challenge the neoliberal notion that corporations should be subject only to the laws of the country in which they were operating at that moment. And in that universal, excuse me, and that universal standards of morality or human rights do not apply to corporations. The Doe plaintiffs, who, by the way, had to be smuggled out of Myanmar through a human smuggling network in order to participate in this trial, asked the courts hold the corporation liable, even though the alleged acts occurred outside of the United States. What they were really asking was for the court to impose legal, ethical, and moral standards on a corporation and hold that those standards followed that corporation around the world wherever it went. The peasants eventually settled with Unical for a significant sum. I believe it was $32 million, if I remember correctly. And it appeared that the corporation preferred to pay out a large sum of money than have the United States Supreme Court rule that the corporations could be held liable for human rights abuses whenever they occurred. What's significant about this case is that these transnational campaigns do not reflect a movement that has switched its focus to transnational corporations. Rather, they reflect the Free Burma movement activists' strategic choices to target the political, legal, and moral discourses that are embedded in and that give meaning to the rules and institutional arrangements that legitimate the transnational partnerships between these transnational corporations and the Myanmar state. These transnational partnerships are in many ways sustained by the states in which these transnational corporations are chartered, as these campaigns have demonstrated. In short, the targets of the movement have also become transnational. So I'll stop with that description, but I want to emphasize that this had a huge impact on this pro-democracy movement by extending its reach to tap sources of power outside its own country that it could deploy within. Eventually, the Alien Tort Claims Act suit itself became emulated by many other movements around the world and scared so many corporations that they put loads of pressure on not only US presidents, but on the Supreme Court to start undoing pieces of this law, which was able to hold transnational corporations accountable for human rights abuse.
Thank you so much, John, for that fascinating account. It's a little known history, I think, especially by some of the younger activists in the civil disobedience campaign. So now we're going to transition into the period of reform that took place largely between 2010 and 2020. And the first question is to Jonathan. I was wondering if you can just kind of give a broad overview of the nature of the reforms that were carried out between 2010 and 2020 in terms of the judiciary system and also in terms of the role of prosecutors in the legal system.
Yeah, so there was a very comprehensive effort by various international aid organizations to further the reform of the legal system in Myanmar. Starting about 2010, really took off around 2012, 2013, and was ongoing at the time of the military coup. So, generally speaking, it's a situation where there was an attempted reform, but it was abbreviated or it was interrupted. So it was reforms with respect to laws, but also reform with respect to institutions. So with respect to the institutions I'm talking about, there was capacity building efforts for lawyers, the legal profession. So this attempts to create an independent lawyers association of Myanmar to encourage independence of the profession of itself on a national scale. There was capacity building efforts within the Attorney General's office and the Supreme Court, so the judiciary, basically to give them increased understanding of international norms and standards regarding the nature of the law, about rule of law, about the expectations for their professions, and also regarding the position of laws within the country and the kinds of reforms that were ongoing. So a lot of these efforts were being supported by organizations. There were NGOs such as the International Bar Association, International Commission of Jurists, Danish Institute of Human Rights, SIDA, which is the Swedish International Development Agency. There was also national aid efforts. So this is where USAID, British Council, the Australian Department of Foreign Affairs and Trade, JICA, which is the Japanese aid organization, the Korean KOICA aid organization. They were also providing support. And then there was also professional outreach. So you had bar associations, for example, in Malaysia and Singapore that were trying to help their colleagues, professional colleagues inside the country in Burma or Myanmar. You also had ASEAN Judges Association that was working across Southeast Asia, that was also working to support the judiciary in Myanmar. Attendant with all of this, there was attempts to also reform the laws. So specifically to reform the Bar Council Act to restore the independence of the legal profession so that it was self-regulating. It had its own, it could possibly have its own licensing system, that it would also have its own discipline system. That was something that was ongoing. They managed to succeed in amending the act so that it would restore elections to the members of the legal profession. They could choose their own representatives on their bar council, but there were further amendments that were ongoing that were interrupted by the coup. There were also a swath of reforms in the laws regarding the penal code, civil criminal procedure, evidence, and those were ongoing as well. Not all the reforms were completed at the time of the coup. And as a result, we had a situation where it was very much stopped before it really could have effect, gain traction or gain effect, go ahead and carry forward a change in the system. So a number of themes I'll note here just for viewers. First was that because of the history of the legal system and the legal profession in Myanmar and the erosion that had occurred over the course of several decades, there needed to be systemic transformation, right? There needed to be a change in the ecosystem. There needed to be a change in the laws. There needed to be a change in the institutions. But capacity building could do some of that work. However, what there also needed to be was a major change in the Constitution, because the Constitution, some viewers may not know, retained a position for the military within the parliament, within the legislature, within the executive. It also accorded the military control over 3 ministries, very powerful ministries. So it was border affairs, security, home affairs or home administration. And until that structural change occurred, there was only so much that empowered lawyers, judges, or prosecutors could do. The other issue that was not completed was that they needed to they were trying to change the promotion system to try and get away from the patron-client structure within the Attorney General and also the Supreme Court. Again, that process was interrupted by the military coup in 2021. The last thing I'll note here was the education system. So there was an attempt to improve the law schools as well as an attempt to improve the professional training within practicing lawyers, within prosecutors, and within judges. Some Westerners would use the term continuing education. These were all in their nascent infancy, and those kinds of changes were ongoing, but because of the coup, all of those efforts were stopped. The last thing I'll note here is that we want to be careful and not say that these institutions are monolithic. There were judges that were very much pro-reform. There were prosecutors that were very much pro-reform. And so it's a situation where you can see somewhat of a generational divide. There's an older generation that was very loyal or continues to be very loyal to the status quo. So that includes military, or they're very reluctant to challenge the status quo. There was a younger generation that was attempting to implement reforms, and they were trying to improve their own understanding of how to do those reforms. But unfortunately, because of their position, their relatively junior position, many of them were silenced as a result of the coup. And there's also, many of them have been purged as a result of the coup. So I'll stop there. Thanks.
Thank you so much, Jonathan. So Dr. Htun, I wondered if you could talk about, so you saw firsthand some of these legal reforms that were instituted between 2010 and 2020 as it played out in the university system. So could you talk a little bit about that and describe what types of changes you observed?
Thank you. Yes, you are absolutely correct. The number of educational reforms, including those affecting the legal education, have been implemented since 2010 by Thein government and civilian government as well. The long closed foreign doors were finally opened, and then, comprehensive education sector review has been put into motion. As a result, the government has embraced the UN and other international organizations, international universities from other countries were invited to sign the MOUs and MOAs, as well as to conduct the educational activities such as awarding more scholarships. Actually, at the military dictatorship time, we didn't have many scholarships, and those scholarships awarded to the military favored professors and professionals. So there were a lot of reformations in education, and then we can teach the human rights law and the undergraduate program. That is great reformation to the legal education. And we can do the extracurricular activities, mock trial, moot court, internship, externship, such like the extracurricular activities that's studied in the universities. And we could change the teaching methods, student-centered methods, like the interactive teaching methods. Actually, when I was student, the teachers used the teacher-centered approach only, and they could translate the legal terms only. So, we made the great efforts for reformation in legal education, but there is the centralized education system in that civilian government. The civilian government could encourage for the research activities to put the research in the universities, and they set up the education expense for research activities. But we don't have the academic freedom, because my specialization is human rights law, and I wrote the human rights law articles, and I wrote about the citizenship problem to Rohingya issues. And I was slammed by the government and senior professors for my research work that revealed how stifled our academic freedom is. And there are no reformation in many facts. There is no mother tongue language system in Myanmar legal education. I was appointed at Taunji University in Shan State. The majority of students are the new Pa'o Pala, like Dr. Jonathan is Pa'o ethnic, so he might know more than me. They face difficulties in learning legal terms in both Burmese and English language as well. So, and then ethnic people don't trust the justice, as Burmese judges and lawyers are at the trial and they don't understand Burmese language very well. So, I can see that the courtrooms and classrooms have to be connected, and legal education shall solve these problems. And, there is no change in distance education. Under Boniwen's administration, distance education was referred to as correspondence. Instead of a name, the system was very similar, as University Distance Education established an assignment system that students were required to submit twice a year. In UD, the same credit points were awarded for 2 assignment submissions and 10 days of teachings over the course of an academic year. Those are not fair compared to students on the surface, but they didn't really address the community needs. Yeah, and we never have the students' needs assessments because curriculums are set up by the Board of Study, which is usually here at the Law Department of Yangon University. Before the beginning of an academic term, professors from the law departments around the country used to meet at the Yangon University for the curriculum discussion. I never hear that they make survey the students' needs and country needs, and some universities deliver tuition for their any, and I have heard that some law departments manage to take teaching assignment subjects by drawing lots. It's such a shame. I'm sure that no one knows every subject. So I was wondering if teachers draw lot and subject what they are not specialized. So, this made the students will impact a lot. This is also a big problem in legal education. And I have one more fact about civilian government cannot reform on academic term. They never consider about the federal education system, because there are a lot of ethnic people in my country, and where the natural resources and human resources vary by the states and regions. But academic terms are set centrally at the same time. Shan, Khin, and Chin states are so cold at the winter and heavy rain at the rainy season. And, transport systems are awfully bad because of low infrastructure. Teachers from the urban areas like Yangon and Mandalay universities don't go to serve at the ethnic location. So, there is no human resources in those ethnic areas. So reformation by Thein government as well as civilian government could not solve these problems for the sake of the ethnic people. This is very big issues in my country. Actually, legal education as well as the education system have to be considered for the ethnic people and for the development of the ethnic areas. Thank you so much.
Dr. Seinenu, you're on mute.
Oh.
Thank you, Dr. Htun, for that. It would be fascinating if we have time later on to have discourse between you and U Kim Aung about I know that you went through the legal education system under the military junta, and then at one point decided to participate in the civil disobedience campaign. So would be curious to know what inspired you to finally participate in 2021 versus staying within the educational system and working within the system there. My next question is for U Kim Aung. So U Kim Aung, I know that you worked for many years to establish mechanisms for legal aid to marginalized communities in conjunction also with prison reform efforts. So I was wondering if you can talk a little bit more about these efforts and some of the processes of engaging in these types of reform during the civilian era.
မြန်မာလို့ပြောမယ်နော်အဲ့တော့ဟောကျွန်တော်ကတော့ဒီ2012ပေါ့လေနော်မြန်မာပြည်ပြန်ရောက်တဲ့အခါကျတော့အဲ့ဒီအချိန်ကမြန်မာနိုင်ငံကလည်းဒီ political transformation ဖြစ်တာပေါ့နော်liberalization ပေါ့ democratic transition ဖြစ်တာပေါ့အဲ့ဒီကာလမှာဖြစ်ချင်းပဲကျွန်တော်ကဒီရုပ်ပင်ဆိုတဲ့ဟောပေါ့ NGO ပေါ့နော် NGO တခု join တယ်အဲ့ဒီမှာဒါ legal aid ဆိုတဲ့ပထမဆုံးကိုယ်တိုင်ကောင်မှပဲဒါ legal aid နဲ့ပတ်သက်တဲ့concept ကိုပထမဆုံးစပြီးတော့သိတာပေါ့လေနော်အဲ့ဆိုအဲ့ဒီမှာ join ရနေပြီးတော့ကျွန်တော်ရဲ့ဒီ2012ကနေ2019ခုနှစ်ကာလအတွင်းမှာပေါ့နော်ဒီဥပဒေအထောက်အကူပြုရေးဆိုင်ရာနဲ့နောက်ပြီးတော့ legal reform တွေပေါ့နော်ဥပဒေပြုပြင်ပြောင်းလဲမှုတွေမှာကျွန်တော်ပါဝင်ပတ်သက်ခွင့်ရခဲ့တယ်ပေါ့နော်အဓိကပတ်သက်ခွင့်ရတဲ့နေရာတွေကတော့ဒီ လွတ်တော်ကနေလွတ်တော်မှာဆိုရင်တော့ဒီဥပဒေထောက်ကူပေးရင်းနဲ့ပတ်သက်တဲ့ဥပဒေပြဋ္ဌာန်းနိုင်ရေးတွေပါတယ်နောက်တစ်ခုကအပြင်မှာကြာရင်တော့ဒီဥပဒေပညာပြန်ပွားရေးတွေဥပဒေအထောက်အကူပေးတာတွေနောက် PreColonial လို့ခေါ်တဲ့free legal service ပေါ့နော်အဲ့လိုမျိုးပေးတာတွေကိုကျွန်တော်အနေနဲ့ပါဝင်ဆောင်ရွက်နိုင်ခဲ့တယ်ပေါ့လေနောက်အဲ့ဒီထဲမှာလည်းခုန prison research လည်းတစ်ခုအပါအဝင်ပေါ့ဟုတ်
In 2012, when I returned to my country, the country was already in the middle of a transition. So I joined an NGO that specializes in offering legal aid. At the time, I didn't even understood what legal aid was. So that was my first exposure to the concept of legal aid itself. So between 2012 and 2019, I was able to participate in legal aid reform, particularly under the parliamentary system. I was able to help make reforms that allow legal aid. Also, the pro bono legal services offered to certain people. And also, I participated in initiating legal education reform.
So, အဓိကတုတ်ခုခွဲပြောချင်တယ်ပေါ့တစ်ခုကကြတော့ပါလဲဆိုတော့ဒီကျွန်တော်အဲ့ဒီပထမဆုံးဆက်စခြင်းပဲအဲ့ဒီ law ပေါ့နော်မြန်မာ legal aid network ကိုစတင်အကောင့်ထဲပေါ်ရတယ်ပေါ့လေအဲ့ဒါကပါလဲဆိုတော့မြန်မာနိုင်ငံမှာရှိတဲ့အဲ့ law fund တွေနောက်ဥပဒေအထောက်အကူပေးနေတဲ့ရှေ့နေတွေအဖွဲ့အစည်းတွေရှိတယ်အဲ့ဒီအချိန်တုန်းကတော့တိတိတတ်တာလောက်ခွင့်မရဘူးလူတွေအကုန်လုံးကလည်းကြောက်နေသေးတယ်အစိုးရကလည်းဖွင့်မပေးသေးဘူးပေါ့နော်အဲ့ဒီခါမှာဘာဖြစ်နေလဲဆိုတော့အတိတ်တစ်ချိန်ကပေါ့နော်တိတိတတ်တာရောမတိမတတ်ရောဥပဒေအထောက်အကူပေးနေတဲ့ရှေ့နေတွေရှိတယ်တတိရှိပေးနေတဲ့ရှိတယ်ဒီရှေ့နေကြီးတွေကိုချိတ်ဆက်ပြီးတော့ပေါ့နော်တကယ်တော့ကျွန်တော်အဓိကချိတ်ဆက်ရတာတော့မဟုတ်ဘူးပထမချိတ်ဆက်ပြီးသားကွန်ရက်ကိုကျွန်တော်ကဆက်ပြီးတော့ဆက်ခံရတာပေါ့နော်အဲ့တော့ကျွန်တော်အရင်မှာလုပ်ခဲ့တဲ့သူတွေအများကြီးရှိပါတယ်ကျွန်တော်ကအဲ့ဒီကွန်ရက်ကိုပို့ပြီးတော့ခိုင်မာအားကောင်းအောင်လုပ်တဲ့ဒီ law လို့ခေါ်တဲ့မြန်မာ legal aid network ကိုစတင်ပြီးတော့ကျွန်တော်ကအကောင့်ထဲပေါ်ရတာဖြစ်တယ်ပေါ့နော်ဒီ law ရဲ့အောက်မှာပေါ့မြန်မာ legal aid network ရဲ့အောက်မှာပဲကျွန်တော်တို့ကproject တွေ program တွေအမျိုးမျိုးစီမံကိန်းတွေအမျိုးမျိုးချမှတ်ဆောင်ရွက်တယ်အဲ့ဒီထဲမှာဒီဥပဒေအထောက်အကူပေးရေးဥပဒေတစ်ခုပေါ်ပေါက်လာဖို့လည်းတစ်ချက်ပါတယ်ပေါ့
The main thing that I started doing was establishing something called M-Law, the Myanmar Legal Aid Network. Even before my time, there were a lot of lawyers and legal professionals who were either openly and bravely working on these efforts or working underground secretively on the same effort. So I rather inherited this network. So my job was mainly to strengthen the network that was already in existence. And part of that is to establish a framework and infrastructure for offering legal aids.
အဲ့တော့ကျွန်တော်တို့ကဒီပထမဆုံးဒီ legal aid ဥပဒေကိုကျွန်တော်တို့လွတ်တော်မှာပေါ့နော် legal aid ဥပဒေဖြစ်မြောက်ရေးနဲ့ပတ်သက်ပြီးတော့ကျွန်တော်တို့ရေးဆွဲပြီးတော့ကျွန်တော်တို့အဆိုပြုနိုင်ခဲ့တယ်ပေါ့နော်အဆိုပြုနိုင်ခဲ့တယ်ဒုတိယတစ်ချက်ကကျတော့ကျွန်တော်တို့ဒီခုန law အပါအဝင်ပေါ့လေနော်ပြုပြင်အပါအဝင်အခြားဒီ NGO အဖွဲ့အစည်းတွေကနေပြီးတော့အဲ့ဒီကာလမှာအလွန်မတန်ကိုဒီလွတ်လပ်တဲ့အသင်းအဖွဲ့တွေကိုဖွဲ့စည်းခွင့်เนาะမှတ်ပုံတင်ခွင့်မှာအတားအဆီးဖြစ်နေတဲ့အသင်းအဖွဲ့မှတ်ပုံတင်ခြင်းဆိုင်ရာဥပဒေ1988ကပြဋ္ဌာန်းခဲ့တဲ့ဥပဒေဟာအတားအဆီးဖြစ်နေတဲ့အတွက်အဲ့ဒီဥပဒေပြုပြင်ပြောင်းလဲရေးအတွက်ဒါကျွန်တော်က law ရဲ့ဟလာဒီ secretary တယောက်အနေနဲ့ကောအဲ့ဒီအသင်းအဖွဲ့များမှတ်ပုံတင်ခြင်းဆိုင်ရာဥပဒေပြင်ဆင်ရေး advocacy လုပ်ငန်းမှာဒါ consultant ပေါ့နော်ဒီ legal advisor တယောက်အနေနဲ့ကောကျွန်တော်ဟာပါဝင်ခွင့်ရခဲ့တယ်ပေါ့လေနော်
At the time, we were also able to introduce a draft bill for offering legal aids at the parliament, and also at the time, organizations like M-Law and other legitimate NGOs have a hard time registering themselves as a legitimate organization. So I was able to, as the secretary of MLaw, participated in the advocacy group that worked towards reforming the acts and the regulations that are blocking the groups from registering.
ဆိုတော့ဒီအဲ့ဒီအသင်းအဖွဲ့များမှတ်ပုံတင်ခြင်းဆိုင်ရာဥပဒေကိုကျွန်တော်တို့ဒီပြင်ဆင်ဖို့စူးစမ်းပြီးတဲ့အခါမှာMLaw မှာလုပ်နေတဲ့အချိန်မှာပဲနောက်တစ်ခုကျွန်တော်တို့ဆက်ပြီးလုပ်နိုင်ခဲ့တယ်အဲ့ဒါဘာလဲဆိုတော့ဒီဖွဲ့စည်းပုံအခြေခံပြုပြင်ပြောင်းလဲရေးဆိုင်ရာဒီသူလူထုရဲ့အကြံပြုလွှာတောင်းခံပွဲကိုတနိုင်ငံလုံးအနှံ့ road show ပေါ့နော်ကားတွေလေယာဉ်တွေနဲ့ရှစ်နေပေါင်း90လောက်နဲ့ကျွန်တော်တို့ပတ်သွားတာပေါ့ပတ်သွားပြီးတော့တနိုင်ငံလုံးမှာရှိတဲ့မြို့ကြီးတွေမှာပြည်သူပေါင်းတစ်ခါတွေ့ရင်100ကျော်200လောက်နဲ့ပေါ့နော်တွေ့ပြီးတော့ပြည်သူတွေကနေပြီးတော့ဖွဲ့စည်းပုံထဲမှာဘာတွေပြင်ဆင်တယ်လဲဆိုတော့ပြင်ဆင်ချက်အကြံပြုလွှာတွေတောင်းခံပြီးတော့မှကျွန်တော်တို့ဒီ MLaw မှာရှစ်နေပေါင်း20လောက်ပေါ့နော်20ရောက်19ရောက်20လောက်ပေါ့အဲ့လောက်ရှိတဲ့ရှစ်နေတွေကနေပြီးတော့ဒီပြည်သူတွေရဲ့အကြံပြုလွှာတွေကိုအကုန်လုံး combine လုပ်ပြီးတော့ပေါင်းပြီးတော့မှအဲ့ဒီပုံမှာဒါဖွဲ့စည်းပုံဆိုင်ရာအကြံပြုလွှာစာတမ်းပုံစံမျိုးပေါ့နော်ဥပဒေဘာလဲအကြံပြုလွှာပုံစံမျိုးကျွန်တော်တို့လွှတ်တော်ကိုတင်သွင်းနိုင်ခဲ့တယ်ပေါ့နော်
We were able to, under the framework of MLaw, we were also able to organize and put on a roadshow, and it was a roadshow that involves about 50 lawyers traveling around different towns and cities to ask for the public's input on constitutional reform, specifically what kind of things the people would like to see reform as part of the constitutional reform. So after that, collecting all the inputs that we receive through our roadshow, we were able to put together a paper that contains all the consolidated input from the people.
So အဲ့ဒီတစ်ဆက်သေးပဲပေါ့နော်တစ်ဆက်သေးပဲကျွန်တော်တို့ကအဲ့ဒီကာလလုံးမှာဘာနဲ့အဆက်အသွယ်ရလဲဆိုတော့နိုင်ငံတကာရှိနေအသင်းပေါ့နော် IBA နဲ့အဆက်အသွယ်ရတယ်အထူးသဖြင့်တော့ IBA ရဲ့ HRI brand ပေါ့နော် IBA HRI နဲ့ကျွန်တော်တို့အဆက်အသွယ်ရတယ်အဆက်အသွယ်ရပြီးတဲ့အခါကျတော့ဒီမြန်မာနိုင်ငံမှာအဓိကအခက်ခဲနောက်တစ်ခုကဘာလဲဆိုတော့လွတ်လပ်တဲ့ရှိနေအသင်းတွေမရှိဘူးပေါ့နော်ဒီလိုလွတ်လပ်တဲ့ရှိနေအသင်းတွေမရှိတဲ့အခါမှာဒီတရားစီရင်တဲ့ဘက်မှာပြည်သူလူထုအတွက်voice တွေပေါ့နော် voice မထုတ်နိုင်ဘူးပြည်သူလူထုကိုကာကွယ်နိုင်တဲ့ institution တွေကခိုင်မာအားမကောင်းဘူးပေါ့နော် legal institution တွေကခိုင်မာအားမကောင်းတဲ့အတွက်မြန်မာပြည်မှာလွတ်တဲ့ရှေ့နေအသင်းတရဲ့ဒီရှေ့နေတင်တယ်ဆိုတဲ့အယူဆနဲ့ဒီ IBA ကလည်းဒါကိုသူတို့ program ရှိတယ်ပေါ့လေအဲ့မှာကျွန်တော်တို့ ਨੇ ချိတ်ဆက်ရပြီးတော့မြန်မာနိုင်ငံမှာပထမဆုံးရှေ့နေတွေနဲ့လုပ်တဲ့ conference ကြီးတစ်ခုကိုလုပ်နိုင်ခဲ့တယ်ပေါ့နော်အဲ့ဒီ conference ကြီးကနေပြီးတော့မှကျင်းပပြီးတဲ့အခါမှာဒီကျွန်တော်တို့လွတ်လပ်တဲ့မြန်မာနိုင်ငံရှေ့နေအသင်းရဲ့တရေလို့ခေါ်တဲ့ပထမဆုံး steering committee ကိုဖွဲ့စည်းပြီးတော့မြန်မာတနိုင်ငံလုံးမှာရှိတဲ့ရှေ့နေတွေကိုလိုက်တဲ့စီယုံပြီးတော့ကျွန်တော်တို့ဟာဒီရွေးကောက်ပွဲရှေ့နေရွေးကောက်ပွဲကိုကျင်းပပြီးတော့မြန်မာနိုင်ငံလွတ်လပ်တဲ့ရှေ့နေအသင်းကိုအကောင့်ထဲပေါ်နိုင်ခဲ့တယ်အဲ့ဒီအသင်းကနေပြီးတော့မှကျွန်တော်တို့ဟာပထမဆုံးဦးစားပေးအနေနဲ့တရားလွှတ်တော်ရှေ့နေများကောင်စီဘာကောင်စီ Act Reform ကိုကျွန်တော်တို့ကြိုးစားပြင်ဆင်ဖို့ကြိုးစားခဲ့တာဖြစ်တယ်ပေါ့နော်
At the same time, I was also able to come in contact with IBA, an International Lawyers Association, specifically with the HRI branch. So as a result of that, I come to realize that there was no such thing as an independent lawyers organization in Burma. And part of the consequence of that was that there was no voice that would speak for the people in the interest of the people. So we were able to, for the very first time in the country, organize a lawyers conference, a conference for the lawyers. And as a result of that conference, after the conference, we formed a steering committee to start electing lawyers. And after that, form what will later become the Myanmar Independent Lawyers Association, Myanmar Lawyers Association. This is part of, and as part of that association, we were able to start working on the Bar Council Act.
အဲ့တော့နောက်တစ်ခုကတော့ဒီထဲမှာပါတယ်မိကွန်းထဲမှာပါတယ်ဒီ prison reform ပေါ့တကယ်တော့ prison reform ဆိုတာကတော့ ကျွန်တော်ခုနလုပ်နေတဲ့ legal aid အပြင်ပေါ့နော် legal aid နဲ့ပတ်သက်တဲ့အဖွဲ့အစည်းတွေနဲ့အပြင်ကျွန်တော်တို့မှာဒီ non-profit တဝက် partial တဝက်ဒီ law fund လေးတစ်ခုကိုတငယ်ချင်းတွေနဲ့ထောက်ထားတာပေါ့နော် Justice for All Law Fund လို့ခေါ်ပါတယ်ဒီ Justice for All Law Fund က2012ကလေးကတိုင်းကျွန်တော်တို့ကဒီ pro bono legal free legal service တွေလုပ်တယ် legal aid လုပ်တယ်နောက်ပြီးတော့ legal education တွေ workshop တွေကိုတနိုင်ငံလုံးမှာကျွန်တော်တို့ကလိုက်လုပ်တာရှိတယ်ပေါ့နော် program တွေလည်းအများကြီးရှိပါတယ်အဖွဲ့အစည်းပေါင်းစုံနဲ့ပေါ့နော်ထူးသဖြင့်ဒီဟိုပါပေါ့ဒီလူခွင့်ရေးဌာနပေါ့နော်Columbia University နဲ့ရှိတယ်နောက်အခြားဒီဘယ်လိုခေါ်မလဲ donor agency နဲ့လည်းရှိတယ်ပေါ့နော်အဲ့ဒီထဲကမှဒီ prison reform ဆိုတာကတော့ဒီ Democratic Dignity အဖွဲ့နဲ့လုပ်တဲ့ program တာဖြစ်တယ်ပေါ့နော်အဲ့ဒါကတော့အထူးသဖြင့်အကျဉ်းထောင်တွေနဲ့ပတ်သက်တဲ့ literature ပေါ့နော် prison literature prison research and literature မြန်မာပြည်မှာမရှိတဲ့အခါကျတော့ဒီမြန်မာပြည်မှာဒီလိုဖိနှိပ်တဲ့ဥပဒေတွေပြုပြင်ပြောင်းလဲဖို့ပဲဖြစ်ဖြစ် penitentiary law တွေပြုပြင်ပြောင်းလဲဖို့ပဲဖြစ်ဖြစ်လာဒီထောင်နဲ့ပတ်သက်တဲ့အဲ့ဒါစနစ်တွေပြောင်းလဲဖို့ပဲဖြစ်ဖြစ်အခြေခံလိုအပ်ချက်ကဒီဟာတွေကိုသေချာသုတေသနပြုလေ့လာထားတဲ့ဟနာပညာရပ်ဆိုင်ရာဒါစာပေတွေစာတမ်းတွေရှိထားတဲ့ဆိုတဲ့အခြေခံယူဆချက်ရှိတာပေါ့လေနော်ဟုတ်
Part of my work, what I was able to do was also form Justice for All Law Firms, a group that offers pro bono legal services and workshops and legal education. And after that, I was also able to come and in these efforts, we work in combination with in collaboration with the Columbia University's Human Rights Research Division. I also came in contact with the Denmark-based Dignity Group, and the Dignity Group's focus is prison research. And we also felt that there was such a lack of documents, scholarly documents and papers that are about the prison system. So part of that, we started working on producing documents and research papers based on our prison systems to start as the very foundation of prison reform.
Thank you so much, Ukimawin. As we move into our last topic, which is sort of the current situation since the coup, if audience members would like to pose any questions to our panelists, if you can please start typing that in now as I pose the last couple of questions to our panelists. So we can transition right into the Q&A. We will be going until 4 p.m. For those of you who can stay. If you can't stay, this panel will be uploaded to the UC Berkeley Center for Southeast Asian Studies website on YouTube so that you can view it at a later time. So my next question, as I said, just moving into the situation right now since the February 2021 military coup, my question is for John Dale. So John, so there are really just a number of initiatives being taken by international actors and interlocutors, particularly in the Burmese diaspora community in response to this current coup. So I was wondering if you can evaluate these different courses of action, including proposed sanctions and efforts to pass legislation in the United States based on what you know about the relative success and failures of the Free Burma movement.
Yes, the easy question. Well, let's see. I think one important international call that we've heard is for the UN to not recognize the military as the government in Myanmar, to recognize those that were democratically elected by the country. That has not gained enough traction. We keep seeing that issue being pushed to the fore among different international bodies. I think that is important, even though it's don't think that that's likely to happen soon. I have been given encouragement by some of the response to what's happening in Ukraine and watching the pro-democracy movement in Myanmar reaching out to Ukraine as well. We see it through the Milk Tea Alliance efforts. And so this is sort of symbolic alliance, but it's very important as a show of solidarity. I think it also sets up an opportunity to start making interesting comparisons, which I'll get to in a second. But the next thing I guess we could talk about is the Burma Act of 2021. This is a bill known as HR 5497. They're voting on it this week. I expect it to pass. It's a bipartisan bill, but then it has to go to the Senate also. I don't think it's going to have trouble going through. The measure holds the perpetrators of the coup and ensuing atrocities accountable through targeted sanctions against the Myanmar military, the State Administration Council, and the affiliated entities and conglomerates. And it authorizes sanctions, importantly, on the Myanmar oil and gas enterprise, which represents a critical revenue stream that finances the junta's violence, I guess. So that's important. Furthermore, and this is important, this violence escalated, civilians have also faced very dire conditions that are compounded by COVID-19 and the collapsing financial system. So since the coup, we've seen 32,000 people, at least, I think it's more than that actually by some numbers, who've fled from Myanmar to neighboring countries. And the Burma Act, this iteration of the Burma Act would also authorize over, I think it's $220.5 million US dollars in humanitarian aid in 2022 to support cross-border assistance for refugees in Bangladesh, Thailand, and the region through civil society and international organizations. Now, I think more impressively have been the sanctions that have come out of the European Union. They recently launched a fourth round of sanctions targeting, I guess, 22 new individuals with asset freezes and travel bans, bringing the total number of targeted individuals by the EU to 65 since the February 2021 coup. They call them, smart sanctions. They're not like the selective purchasing laws I talked about earlier, or individual federal or state sanctions, national sanctions. But these also target the Myanmar oil and gas enterprise. And to emphasize that represents about 50% of Myanmar's foreign currency that comes from natural gas revenues. So I think while that's not enough on its own, even these two working together, I think that does show that sanctions, they've been increasing the pressure through these sanctions and starting to create ones that have more teeth. But of course, there are other actors who can support Myanmar. So China and Russia, being two important actors, have also been providing arms to the Myanmar military. There have been calls at the UN for a global arms embargo, but it would have to ultimately go not just to the Human Rights Council within the UN, which this week has been calling for or received calls to maybe kick Russia off the Human Rights Council because of its invasion in Ukraine, which could change the dynamics there for Myanmar as well. But you also have China that has veto power at the UN Security Council, and that's ultimately what it would take to enact this global arms embargo. Also, this fight right now that the pro-democracy movement is engaged in is also relies to a large extent on weapons and munitions, and a global ban would be a global ban for everyone. And I know that's very controversial. I'm not siding with whether the right strategies to take up arms or not, but there's a lot of this happening in self-defense, and many reports recently have suggested that accessing arms has become very difficult, even though the military, Myanmar military, still has weapons coming in from its usual sources and more. And so I think that's a very tricky call, the global arms embargo. We've been talking about it for a very long time. At this moment, I'm not sure how much support there is. I'd be curious to hear within the pro-democracy movement in Myanmar. And then, of course, there are other issues. Australia has been changing a few of its immigration laws to create benefits, I mean, really incentives for Myanmar soldiers, including officers, high-level officers, to encourage them to defect and go to live in Australia with full pensions and insurance. Some soldiers have been already taking advantage of that. I think that's kind of an interesting new strategy. I've had not really seen that before. And then there are issues around, these are tricky ones, around some of the, internet and communications technology providers. So Telenor recently, as you know, has decided to leave Myanmar. They've sold, I think just last week, I think it was finalized. They've sold company to M1, a Lebanese company, M1 Group, and let's see, the local, I think that it's a Shui Bien Phu. I don't know if I'm pronouncing that correctly. A local group in Myanmar that'll also be one of the new part owners of what was Telenor. The thing about those assets is that it also includes the data, which is the biggest asset of all that Telenor has, personal data of people in Myanmar. So I don't think there are any laws right now that are in place to protect those kinds of assets and how they'll be used moving forward. But that to me seems like a very important issue. So I'm not suggesting that is a current action that I evaluate, but it's one I'd put on the table and think that it's, that could go a long way towards helping people in Myanmar who now I see fighting a new kind of battle this time around. With these digital technologies, I think has come a particular form of digital authoritarianization in Myanmar. We see it in the United States. Silicon Valley has its own version of this. It's often referred to as surveillance capitalism. But the one that Myanmar has been adopting is more like China's surveillance state. While opening up the internet initially seemed like a boon for the pro-democracy movement, I think on balance, the military has been able to use it to more advantage, taking over all this data from Telenor. And if they were to take over from Ooredoo or be able to get Ooredoo to do what it wants, which was why Telenor wanted to leave, because it didn't want to comply with what the military wanted them to do. This could be very devastating for people living inside Myanmar. So I don't want to take up too much more time because I know we're running short, but those are some of the immediate assessments of that.
Thank you so much, John. So with that, I'm gonna turn to the question and answer from the audience. I have a couple of questions of my own. I can see why we need a series on the legal system in Burma, especially in relation to the democracy movement, because there's so many fascinating issues to cover. There's a few questions by an audience member, Paul Sarno, and I'm going to read, because they're short questions, I'm going to read all of them and try and combine them into sort of one question. He writes, how are judges chosen in Myanmar? Or how were judges chosen in Myanmar 2015 to 2020? Did the NLD government succeed in changing the quality of judges at all? And then another question that he had was, is the USDP, so the Union Solidarity and Development Party, which is the political party of the military. So for USDP, was membership required to join? Was USDP membership required to join the prosecutor's office and the attorney general's office? And then his other question was, do the judges tend to live near or in military compounds? Where and how do they live? So he's asking more broadly about the positionality of these judges in relation to both the USDP and military. And I don't know who wants to take that question.
Yeah. So I typed my answers in a little bit, but I'll try to summarize just quickly as I can. So with the judges specifically, there was a process ongoing from 2015, 2020 about trying to change the promotion system. So there's going to be more merit-based and less tied to the references or the decisions of superiors. superior judges. That was largely supported by international aid efforts. It was ongoing. The coup, as some of you may know, and has an element of anti-foreign sentiment. So I think a lot of those efforts are in jeopardy or were placed in jeopardy as a result of what happened in February 2021. Regarding the membership of USDP or NLD, not necessarily, at least during the period that I was there. You would see prosecutors, so in the Attorney General's office, and judges in the Office of the Supreme Court of the Union, who were openly members of the NLD. And so that was, and likewise, some who were also openly members of other political parties. So that was not necessarily something that was being expected. But once again, after February 2021, there has been very much a purge or an ongoing purge of anti-military sentiments throughout those institutions. So things may have changed radically since February 2021. The last thing regarding residences and where the judges are living, it depends. So what most people don't know is that within the Attorney General's office and the Supreme Courts, the judiciary and the prosecution, they follow a civil servant practice where they're rotated around the country on a regular basis. It's actually considered part of their promotions requirement that they have served in different parts of the country. And so you'll see a situation where many civil servants, they'll have a primary family residence in an urban area like Yangon or Mandalay, and then they'll have a workstation where they have a temporary residence. And the quality of that depends on where they are. So a junior level civil servant, this includes prosecutors and judges, at least in 2015, 2020, their pay would be around 300,000, 350,000 shots per month, which, that's not a lot if you, by Yangon or Mandalay standards. And incidentally, this was one of the reasons why corruption was a problem, was because you would have judges in particular that would try to find alternative sources of income. So, that includes things like gifts, bribes, but also separate businesses outside of serving as a judge. The pay increases as they go up, as they get promoted, and then the lifestyle will change. So again, it's a situation where I guess the answer is it depends. All right, so hopefully that answers all those questions.
Yeah, thank you so much, Jonathan. I saw Ukimawan smiling, so I wondered if he had a response, especially while Kenneth is still here to translate for him.
ကျွန်တော်ဖြေတာကောင်းပါတယ်ဒီတခုတော့ရှိတာပေါ့ကျွန်တော်တို့မြန်မာပြည်မှာကဒီတရားသူကြီး3မျိုး3စားလောက်တော့ရှိတယ်ထင်တယ်ရွေးချယ်ပုံလေရွေးချယ်ခန့်အပ်ပုံဟိုမှာ constitutional tribunal လို့ခေါ်တဲ့ဖွဲ့စည်းပုံခုံရုံးခန့်တာကတော့ဖွဲ့စည်းပုံအတိုင်းပေါ့လေနော်ရွေးချယ်ပြီးတော့ဒါဖွဲ့စည်းပုံထဲမှာပါတဲ့ criteria ပြည့်ပြီးတဲ့နောက် experience skill တွေပြည့်ပြီးတဲ့ကြော်ကြားတဲ့သူဆိုရင်ခံခွင့်ရှိတယ်ဆိုတဲ့အတိုင်းပဲဒါ constitutional tribunal မှာတော့အဲ့လိုခန့်တာတစ်မျိုးပေါ့နောက် Supreme Court ကတော့များသောအားဖြင့်ကတော့ဒီpractice lawyer ပေါ့ apply lawyer တွေရဲ့အတွေ့အကြုံနဲ့သူတက်တန်းအရာ promotion အရာရောက်သွားတဲ့လူတွေလည်းရှိတယ်စစ်အစိုးရကာလမှာအပြင်ခန့်တဲ့အခုတရားသူကြီးချုပ်ဆိုရင်တော်တော်များများပြောတာကတော့စစ်တပ် background ရှိတယ်လို့ပြောတယ်ပေါ့နော်ဒါမျိုးပေါ့ဆိုတော့အဲ့တော့ဒါတွေကတော့ဒီခန့်ပုံပေါ့ခုန junior judge တွေ legal officer တွေကတော့များသောအားဖြင့် recruit လုပ်တာပါကျောင်းသားတွေ law degree ရပြီးလို့ရှိရင်ဖြေရတယ်ပေါ့နော်ဒီစာမေးပွဲပေါ့အဓိက recruit လုပ်တဲ့စာမေးပွဲတွေဖြေပြီးတော့အောင်တဲ့လူကိုရွေးတာပေါ့လေဒါပေမဲ့မြန်မာပြည်မှာcase ဆက်ဘယ်တော့မှမပြောက်တာကတော့ corruption ပေါ့နော်အဲ့တော့ပေါ့ဆို merit based ပညာရေးတော်တဲ့အခြေခံထက်ပေါ့နော်ဘယ်သူလက်ထိုးနိုင်လဲပြီးနိုင်လဲဆိုတဲ့ပုံမှာတော်တော်လူတော်များတယ်ပေါ့နော်ရွေးချယ်ပုံမှာတော့အဲ့ဒါလေးပါ
I just wanted to add a couple of things about the way the three different types of judges election system. One is the constitutional tribunal system that allows judges that are qualified and have experience and have renown to be appointed. The other one is the Supreme Court judge appointments that are appointed. And the other one is just under the military regime system, of course, the judges that are simply appointed from outside. Also, for junior judges, these are actually recruited among the students who have passed the legal exams and the legal examination. So, but of course, unfortunately, the problem that has consistently plagued Burma's system is the corruption system. So rather than appointing these people and electing them based on merit, it has often been the case where briberies and the kind of gift that one can provide will affect whether one gets appointed or not.
Okay, thank you so much for that, Kim Win. Our next question is from another audience member, G. Thoda Su, and G. Thoda Su writes, the efforts of promoting criminal justice are seen as the effects of promoting criminal justice as seen in 2021 when young lawyers stood up for defending pro-democracy activists prosecuted for anti-coup activities. I would like to know what role the Bar Council and other bar associations should be playing. So I'm not sure I quite understand quite how the question is worded, but it seems like it's asking just the role of the Bar Council and Bar Association in relation to criminal justice. Does anyone have a response to that? Yeah, Jonathan.
Well, so I mean, I can speak to the lawyers. I mean, I don't know about the actual associations themselves. I'm talking about the individual lawyers. Even now, as we speak, you can see that there are lawyers that are trying to defend the pro-democracy activists. They're visiting prisons. They're trying to actually get to them when they're arrested. But a lot of the times they're actually being stopped. So they're not being allowed to visit people who've been arrested. In some situations, lawyers that are too considered troublesome are actually being targeted. So lawyers can actually be targeted and harassed. So you'll see situations where lawyers are being prosecuted by the junta or they're being harassed by military supported gangs. There's also a phenomenon within the Attorney General's office in the Supreme Court where there was civil disobedience, a CDM movement, and those, just like in all the ministries at all levels of the government after the coup. But since February 2021, all of the ministries, so this includes the Attorney General's office and Supreme Court, have been subject to this ongoing purge of anyone involved in civil disobedience. And so, more and more of those actors are disappearing these days. So thanks.
Thank you, Jonathan. And the last question that I have is for everyone, although you have a very, very short amount of time to answer it. And it's really, so if the NUG is successful and the revolution succeeds, what would be the first legal reform that you would recommend to the incoming NUG government? And I'll start with Kim Wing while Sia Kenneth is still here to translate, because I know he has to leave at 4 p.m.
What is the question?
တကယ်လို့များຫນွေဦးတော်လှန်ရေးရအောင်မြင်သွားပြီဆိုလို့ရှိပါတော့အမျိုးသားညီညွတ်ရေးအစိုးရကိုပထမဆုံးအနေနဲ့ပြုပြင်ပြောင်းလဲပေးပါလို့တောင်းဆိုခြင်းနဲ့တရားဥပဒေဆိုင်ရာပြုပြင်ပြောင်းလဲရေးဘာများဖြစ်မလဲခင်ဗျ
Structural reform. So one answer is structural reform, legal structural reform.
I don't think I need to translate that.
Very short.
Yep. I've got a short one too.
Okay.
Constitutional reform and the fact that you can't change the Constitution unless you have 75% of 76% of the vote with the mandatory 75% of the parliamentary seats being constitutionally given to the military. I think that's got to change if you're ever going to be able to have that kind of constitutional reform.
And Jonathan and Suyan.
Yes, it is good question. Actually, we have to reform all the sectors, constitutional reform, staff reform, and education reform, because we have to go to the federal democracy state, and we have to fit the federal democracy education, and we have to consider the benefits of the ethnic peoples and all of the people in country, because our education standard is really, really low, and education is very centralized, I think, for the memory. So we have to do reformation and resettlement when the annuity succeeds. Yeah.
So I'll just add to what everyone else said. It's going back to the very beginning of the session today. We said that this was an ecosystem that has been multiple decades in the making, and it's the kind of situation that it'll take just as long to undo 7 decades worth of erosion. And so I put it into 3 categories. There's the instruments, the laws, the institutions, and then there's the norms. So in terms of the institutions, people have already mentioned the change of the Constitution. That's absolutely necessary, but the new Constitution, when it comes out, it has to focus on a civilian rule. With the military, they need to have the military removed from the legislature, from control of the ministries. They need to have a rights-based focus so that there's an actual coherent body of rights that can be claimed and exercised and referenced in the courts. There need to be laws that are modernized, because even now, Myanmar is using Indian laws that were used in the Indian just colonial era from 1800s. This includes the criminal code, the penal code, et cetera. India moved beyond all of those laws decades ago, and Myanmar never did. With respect to the institutions, there has to be independence of the institutions. So this is the legal profession, independence of the judiciary, independence of the prosecution. These are luxuries that Americans live with, but they're just alien in a place like Myanmar. There has to be greater capacity just to compensate for the weak education. The legal education system has been gutted for so long, and this includes a continuing education system so that the members of the legal profession can catch up with a lot of the global discourses and developments that have occurred. There has to be a merit-based promotion system of some kind. The last thing, and this is probably the most important thing that a lot of international aid organizations forget about, is there has to be a normative change. There has to be a shift away, not just within the legal system in Myanmar, but also in the entire society, that it's not ruled by law. Law is not an instrument of the elites. It's not an instrument of military power. It's not an instrument of political leaders. It has to be ruled by law. And that, that in other words, everyone, no matter who they are, has to be subject to the same laws in the same way all the time. And that, rule of law also means that there has to be some level of trust within the system, that it's not corrupt, and it's not something that's being corroded by external forces or even internal foibles or weaknesses. So these are things that no easy fix. And, we had 10 years from 2010 to 2020, but, that was clearly insufficient to reverse 70 years of erosion. So I think that the first order of business when the NUG takes over is to resume and continue that path of reform, because it's going to take probably another 70 years to really make it complete. Thanks.
On that note, I'll close things off, and I thank all my panelists and the audience for joining us today. Thank you so much to everyone.
Thank you.
Bye.